Coming to the next chapter, that is executive. Prime Minister. Lord Morley described the Prime Minister as primus inter pares, means first among equals, and keystone of the cabinet arc. Ramsay Muir described the Prime Minister as the steering wheel of the ship of the state. Power and functions. With respect to President. First, link between the President and Council of Ministers, Article 78. Second, advice and appointment. Prime Minister advises President on the appointment of other ministers. He recommends the allocation of and reshuffling of portfolios among ministers. Third, it advises the President on summoning and proroguing of Parliament and dissolution of the Lok Sabha. Prime Minister advises in appointments of constitutional authorities, example, Attorney General, CAG, election commissioners, etc. Next, powers with respect to Council of Ministers. First, head of the Council. The Prime Minister is the head of the Council of Ministers and decides the agenda. Second, leader and coordinator. In this, he guides, directs, and coordinates the activities of all ministers. He can ask any minister to resign or recommend dismissal to the President. Third, chairman of meetings. Prime Minister presides over meetings of the cabinet and influences decisions. Next, powers with respect to Parliament. First, leader of the House. Other powers and functions. First is crisis leadership, plays a central role in times of emergency or national crisis. Second, plays a key role in foreign policy decisions and international representation. Next, issues. First, concentration of power in PMO. PMO has expanded into a parallel government, said by Subhas Kashyap. Example, COVID-19 lockdown decisions centralized. Second, erosion of cabinet collective responsibility. Example, 1975 emergency declaration bypassed full cabinet. Uh, Third, presidentialization of prime minister. Shift towards prime ministerial government, example in foreign policy decisions. Fourth, marginalization of parliament, example farm laws 2020 passed with limited debate. Fifth, coalition versus majority dilemma. Prime minister's role weakened in coalitions but over centralized in majority regimes. Sixth, opacity in decision making. Example, PM Cares Fund not under parliamentary oversight. Seventh, institutional weakening. Prime Minister Office dominance sidelines institutions. Example, Niti Aayog reduced to advisory role. Next is way forward. First, introduce a PM's question hour UK model to improve direct accountability. Second, restoring collective cabinet responsibility. That is, define clear guidelines to prevent the PMO from bypassing ministers and functioning as a super executive. Third, internal party democracy. That is, Prime Minister must emerge from transparent intra-party elections. Fourth, bring PM Cares and under RTI. It ensures financial transparency. Fifth, appointment of key constitutional officers such as CAG, CEC, etc. should follow the collegium model involving CJI, leader of opposition, and PM. Sixth, codification of conventions. Draws from UK's cabinet manual, particularly concerning PM's powers, cabinet procedures, and PMO functioning. Next, PMO. Origin. 1947 to 1977, established as Prime Minister's Secretariat to provide central assistance to Jawaharlal Nehru. 1977, it was renamed as Prime Minister's Office during the tenure of Morarji Desai to project a less secretive and more office-like image. Third, evolution. Under Lal Bahadur Shastri, the role of Principal Secretary was created, shifting the PMO from a mere clerical body to a high-level policy advisory unit. Next, key functions. First, secretarial assistance. PMO provides PM with technical and administrative support for managing the Union Cabinet and Parliament. Second, inter-ministerial coordination. PMO resolves interdepartmental disputes and ensures policy synergy. Third, policy monitoring. PMO tracks the progress of big-ticket infrastructure projects via the Project Monitoring Group and flagship schemes like Gati Shakti. Fourth, national security and forensic policy. PMO houses the National Security Advisor and coordinates with intelligence agencies and Ministry of External Affairs. Fifth, public grievances. PMO manages the CP Grams portal and the Prime Minister's National Relief Fund. Major criticism. First, over centralization of power. Critics argue that PMO has become a super cabinet. Second, the PMO has largely eclipsed the Cabinet Secretariat, which is the traditional coordinating body under the rules of business. Third, parallel bureaucracy. The office is seen as creating a shadow government where unelected advisors override the expertise of senior civil servants. Fourth, unitary tilt in federalism. Example, frequent direct meetings between PMO and district collectors have bypassed state chief secretaries. Fifth, opaqueness in decision making. The internal deliberation process within the PMO remains shielded from RTI and public scrutiny. Sixth, politicization of bureaucracy. High-profile retired bureaucrats are frequently inducted into the PMO, leading to allegations of a committed bureaucracy. Next, way forward. First, restoring cabinet supremacy. Uh, that is, re-empower the cabinet secretariat to handle routine coordination, allowing the PMO to focus strictly on the Prime Minister's personal secretarial needs. Second, formalizing consultation. That is, institutionalize a consultation charter where the PMO must seek mandatory input from state governments before intervening in state list subjects. Third, parliamentary oversight. Create a dedicated standing committee or subcommittee under the Public Accounts Committee to specifically audit the functioning of PMO. Now, should India adopt a presidential form of government? First, arguments in favor of presidential system. Number 1, separation of powers. Presidentialism ensures an independent legislature preventing executive dominance. Second, directly elected executive ensures legitimacy from people's mandate. Third, stability of tenure. A fixed tenure not vulnerable to coalition collapses or legislative whims. Fourth, cabinet of talents. Freedom to appoint ministers from outside legislatures, bringing in experts and technocrats. Fifth, clear accountability. Voters can judge an individual leader on performance in governance rather than political maneuvering. Sixth, decisive leadership. Direct election gives a strong mandate for effective governance. Now, coming to Shashi Tharoor's criticism of the parliamentary system in India. First, unqualified legislatures. The system has created a breed of legislatures largely unqualified to legislate, who contest elections only to gain executive power. Second, government instability. Governments are dependent on fickle legislative majorities, forcing them to prioritize politics over policy or performance. Third, Weak political parties. Parties have become shifting alliances of selfish interests, lacking coherent ideologies. Fourth, coalition compulsions. Coalition governments are obligated to cater the lowest common denominator, are diluting governance effectiveness. Last, focus on staying in power. Instead of governance, governments spend energy on managing alliances and survival. Arguments against presidential system. First, Dr. Ambedkar in Constituent Assembly warned presidential system may degenerate into dictatorship. Second, Granville Austin uh, said parliament system balances authority with responsibility through legislative accountability. Third, stain on federalism. Centralizing tendencies erode state autonomy. Fourth, loss of inclusivity. That is, parliamentary coalitions allow broader representation of groups and regions. Fifth, legislative executive friction. Example, US government shutdown. Sixth, spoils system. Risk of appointment being made on political loyalty rather than merit, as seen in US model. Seventh, unsuitable political culture. India's diversity may fuel divisive winner takes all presidential elections. Eighth, emergency President. 1975 showed dangers of excessive centralization under one leader. Next, Sarkaria Commission said India's diversity and federalism require a parliamentary system for inclusive representation. Next topic is presidential reference. Recently, President invoked Article 143(1) of Constitution to seek Supreme Court's opinion on the scope of powers of Governor and President under Articles 200 and 201. The reference follows a recent Supreme Court ruling that set clear timeline for governors and the president to act on bills passed by state legislatures. The verdict also introduced the idea of deemed consent to address delays caused by gubernatorial inaction. It is a power that the president has invoked on at least 15 occasions since 1950. In 1951, India's first president, Dr. Rajendra Prasad, made the first reference to Supreme Court in relation to provisions of Delhi Laws Act 1912, the Ajmer Merwar Extension of Laws Act 1947, and Part C of States Act of 1950. Article 143, Advisory Jurisdiction of Supreme Court. Article 143, Subclause 1, that is a discretionary reference. First, the President may refer to Supreme Court a question of law or fact that is of public importance. Second, the Supreme Court may choose to answer the reference or not. Third, the court's opinion is advisory, not binding, but carries significant constitutional weight. Article 143, second, subclause 2, that is mandatory reference. If any question arises relating to pre-constitutional treaties or agreements, the President must refer it to the court. Second, the court is obligated to give its opinion in this case. Third, Article 145, subclause 3, requires any such reference to be heard by 5 judges, after which the Supreme Court returns the reference to the President with the majority opinion. Important judgments. First, Kerala Education Bill 1958. First use of Article 143(1) set precedent for judicial restraint and clarified that advisory opinion is not binding. Similarly, in Berubari Union Case 1960. In Special Courts Bill 1979, Supreme Court upheld the validity of bill seeking to establish special court for speedy trials of emergency period offences. In Ram Janmabhoomi Case 1993, Supreme Court declined to answer, citing that the reference was hypothetical and not legal in nature. In Kaveri Water Dispute Tribunal, Supreme Court accepted the reference and gave its opinion, stating that tribunal decisions under Article 262 are binding and must be implemented. Coming to the significance of Article 143. First, under the Constitution, the President acts as the aid and advice of the Cabinet. The advisory jurisdiction allows her the means to seek independent advice on constitutional matters. Second, bridge between executive and judiciary. That is, consultation with Supreme Court strengthens coordination and clarity between constitutional organs. Third, clarifies constitutional ambiguities. It helps in interpreting grey areas of constitution, laws, or treaties. Fourth, prevents legal disputes. Advisory opinions can preempt future litigation by clarifying constitutional questions before conflicts arise. Fifth, democratic and transparent governance. It encourages legal scrutiny of proposed policies or actions without adversarial litigation. Sixth, non binding yet influential. Though non binding, Supreme Court's opinion carries great moral and constitutional authority, guiding executive and legislative decisions. Seventh, used in landmark cases, played a key role in Barobari case, Special Courts Bill, and Kaveri dispute, shaping constitutional jurisprudence. Next, major issues. First, non-binding nature of opinion. Second, discretion to decline reference. Example, in Ram Janmabhoomi reference 1993, court declined to answer, citing lack of legal issue. Third, possibility of political misuse. Executive may use Article 143 to politically deflect controversial issues or influence ongoing public debates. Fourth, risks converting the court into a consultative body for the executive. Fifth, lack of procedural guidelines. The Constitution does not specify detailed procedures or timelines for the court to respond for a reference. Sixth, overlaps the judicial review. Advisory opinions under 143 may influence or prejudge issues that could later become the court in a judicial capacity. Later come before the court in a judicial capacity. Next, way forward. Make advisory opinion binding in limited cases such as constitutional interpretation, federal disputes, emergency powers, etc. Second, introduce time-bound procedure for the Supreme Court. Third, establish clear guidelines either through statute or Supreme Court rules on what constitutes a valid question of public importance and when the court may decline a reference. Fourth, publish detailed reason for refusal. Fifth, require the government to take and report in Parliament on court's opinion. Supreme Court judgment on Article 200 and 201. A division bench of Justice J. B. Pardiwala and R. Mahadevan ruled that Tamil Nadu Governor R. N. Ravi's withholding of 10 state bills was illegal and erroneous. The court clarified that the governor's power under Article 200 are limited and must be exercised within constitutional bounds. Invoking Article 142, the bench held that the pending and reserved bill are to be treated as having received deemed assent. Article 200, Governor's power. First, in Article 200, the first point is three executive options. A governor may grant assent, withhold assent, and return for reconsideration, or reserve the bill for president. No pocket or absolute veto exists. Second, time limits imposed. Withholding or reserving on counsel advice within 1 month. Withholding against advice, return within 3 months with reasons. Repassed bills, assent immediately within 1 month. Judicial review. Governor's inaction or misuse is justiciable. Courts can examine arbitrariness or malafide. Next, Article 201, President's power. First, 3-month deadline to decide on bills reserved by governors. Delays beyond must be accompanied by written reasons. Second, no pocket veto. President cannot indefinitely withhold assent. Deemed assent if unreasonably delayed. Third, proviso to Article 201, return and repass, must not be used piecemeal to delay legislation. Once repassed, the President must grant or withhold assent with clear reasons. Fourth, judicial review. Limited scrutiny where union interest predominates. Deeper review where state primacy and state cabinet advice conflict. Next, significance of the judgment. First, curtails arbitrary use of Article 200. Second, prevents politicization of office of governor and president. Third, protects separation of power, reclaims the primacy of legislature in lawmaking by limiting executive interference. Fourth, establishes time limits for decisions on bills, ends the practice of pocket veto. Fifth, strengthens legislative supremacy in states. Sixth, concept of deemed assent introduced sets a powerful precedent for ensuring legislative continuity and constitutional efficiency. Seventh, promotes constitutional morality, reinforces the expectation that constitutional authority must act in good faith and not stall democratic processes. Next is major issues in the judgment. First, judicial overreach. Example, legal doctrine of deemed assent not explicitly found in Constitution. Second, ambiguity. Unclear how deemed assent will be operationalized or enforced. Third, the judgment reaffirms limited discretion for governors but doesn't fully define the scope of constitutional discretion under Article 200. Fourth, one size fit all federal application does not account for varying political, administrative, or legal complexities across different regions. Fifth, lack of direct accountability mechanism for governors. Without structural reforms, governor may continue to act at the behest of center without consequences. Coming to the way forward, ensuring constitutional discipline and cooperative federalism. First, codify timelines into law or constitutional amendment. Second, define and limit governors' discretion constitutionally. Third, create a parliamentary or judicial oversight mechanism to track delays in grant of assent. Fourth, introduce a code of conduct for governors linked with review mechanism by the interstate council or Rajya Sabha. Fifth, frame guidelines for future use of Article 142 to prevent charges of judicial overreach. Sixth, institutionalize regular center-state consultations through Niti Aayog or Interstate Council on issues affecting federal relations. Next topic is Council of Ministers. Introduction and quotes. The cabinet is the steering wheel of the ship of the state, said by Ramsay Muir. Second, the cabinet is the keystone of the political arc, said by Lowell. The cabinet is the pivot around which the whole political machinery revolves, said by Sir John Marriott. Next, constitutional provisions. Article 74. Council of Ministers to aid and advise the President. This advice is binding on the President after the 44th Amendment of the Constitution. Second, Article 75. Composition of Council of Ministers, their appointment, tenure, responsibility, etc. Article 77. Conduct of business of Government of India. Article 88. Ministers can speak and participate in either house of the Parliament, joint sittings, and committees but cannot vote. Fifth, 91st Amendment Act 2003 limited the size of Council of Ministers to 15% of Lok Sabha or State Assembly members to prevent excessive appointments. Coming to the powers and functions of Council of Ministers. First, collective responsibility. Under Article 75, Subclause 3, the Council is collectively accountable to the Lok Sabha for all executive decisions. Second, Formulation of national policy. The Council deliberates on and decides all major domestic and foreign policies of nation. Third, aiding and advising the President. Under Article 74, the Council provides binding advice to the President on all executive functions. Fourth, legislative leadership. Ministers draft and introduce almost all major government bills and steer them through both houses. Fifth, financial management and budgeting. The Council is responsible for preparing the Union budget and ensuring fiscal discipline across ministries. Sixth, Supreme Executive Control. Each minister oversees the administration of their assigned department, ensuring the implementation of government programs. Seventh, coordination of administration. The Council ensures synergy between different departments to avoid policy conflict and overlapping jurisdictions. Eighth, proclamation of emergency. The President can only declare a national emergency, Article 352, upon written advice from the Cabinet. Now, coming to the difference between Council of Ministers and Cabinet. First, in terms of constitutional mention, Council of Ministers is mentioned in 74-75 Constitution Act, constitutional article. Cabinet is not explicitly mentioned but exists as core decision making body. It is mentioned in Article 352. Size. Council of Ministers is a larger body, includes all categories of ministers, that is Cabinet Minister, Ministry of State and Deputy Ministers. Cabinet is a smaller body, includes only senior cabinet ministers. Third, composition. Council of Ministers are composed by cabinet ministers, ministers of state, independent charge and attached, and deputy ministers. In cabinet, only cabinet ministers are there. Meetings. Council of Ministers rarely meet as a full body. Decisions are taken by cabinet or individual ministers, while cabinet meets regularly to discuss and decide on government policy and administration. Decision making power. Cabinet Council of Ministers collectively responsible to Lok Sabha, but real decisions are usually taken by cabinet. So cabinet are the real executive authority. Its decision bind the entire Council of Ministers. Coming to the cabinet. The cabinet is the core of Council of Ministers and the highest decision-making authority in the Indian politico-administrative system. It was not included in the original text of Constitution, and the 44th Constitutional Amendment Act 1978 inserted cabinet into Article 352 of the Constitution. Significance of the cabinet system in India. First, real center of executive power. That is, it drives national policy, handles administrative affairs, and directs all ministers and departments. Second, principle of division of labor and effective delegation. That is, it enhances specialization, expertise, and sectoral focus within governance. Third, supreme policy formulation. It serves as the highest authority for determining national priorities and long-term strategic goals. Fourth, interministerial coordination. It resolves jurisdictional overlaps between different ministries to ensure a unified whole of government approach. Example, PM Gati Shakti. Fifth, all major government bills and constitutional amendments must receive cabinet approval before being introduced in parliament. Sixth, financial oversight. The cabinet approves the union budget and all major public expenditure proposals exceeding specific fiscal threshold. Seventh, binding advice to President. Under Article 74, its advice is binding, making it the de facto wielder of the President's power. Eighth, it determines India's stance on international treaties, global alliance, and strategic defense agreements. Ninth, and the government's written recommendation is mandatory for the proclamation of national emergency under Article 352. 10th, it oversees the selection of heads of armed forces, intelligence agencies, and major constitutional bodies. Coming to the issues with cabinet system. First, top-down approach in decision making. overshadows other ministers, limiting diverse inputs in policy making. Second, lack of transparency. Cabinet meetings are confidential, reducing transparency about decision making process. Third, concentration of power in Prime Minister reduces cabinet to a rubber stamp in strong majority governments. Fourth, erosion of collective responsibility. Cabinet decisions are often shaped by a smaller inner circle or PMO, not through broad ministerial deliberation. Fifth, the Prime Minister's office functions as a parallel power center, weakening cabinet committees and interministerial consultation. Sixth, the coalition compulsions and policy paralysis due to political bargaining, compromises, and external pressures. Seventh, limited parliamentary oversight. The example money bill and ordinances are often passed without serious discussions, sidestepping majority scrutiny. Eighth, administrative overload. Example in 2026, over 40% of the cabinet agenda items were reported to be procedural rather than policy oriented. Ninth, the kitchen cabinet phenomenon. Crucial decisions are often made by a small inner circle of 2-3 ministers, sidelining the larger cabinet. Coming to the way forward to strengthen the system. First, formalizing consultation. Adopting the Panchi Commission's recommendation for mandatory state level feedback via the Interstate Council. Next, second number, empowering ministry level research. That is, each cabinet minister should have a policy unit of domain experts to reduce dependence on the PMO. Third, strict parliamentary sittings. That is, increase the number of mandatory parliament days to 100 plus annually to ensure cabinet accountability. Fourth, shadow cabinet traditions. Encourage the opposition to form a shadow cabinet to provide constructive alternative to rigorous scrutiny. Example in UK and Australia. Fifth, reforming the rules of business. Update the 1961 rules to clearly define the boundaries between PMO, coordination, and cabinet authority. Coming to the next topic, Constitution 130th Amendment Bill 2025. The primary aim of the bill is to uphold constitutional morality um, by preventing the PM, CM, and ministers from continuing in office while in judicial or police custody for an extended period. Coming to the key provisions. First, if a minister is arrested and remains in custody for 30 consecutive days on serious criminal charges, uh, that is, offences punishable by 5 years or more, they will automatically lose their office. Second, reinstatement clause. If the leader is later granted bail or cleared through the legal process, they may resume their position. Third, universal application. Unlike previous historical attempts like 39th Amendment which sought to shield high officers, this bill specifically includes the PM within its purview. Fourth, two related bills: the Territories Amendment Bill 2025 and Jammu Kashmir Reorganization Bill 2025 were introduced simultaneously to apply these rules to UTs like Delhi, Puducherry, and Jammu and Kashmir. Coming to the arguments in favor. First, constitutional morality. That is, prevents leader from continuing in power while facing serious criminal charges. Second, good governance. That is, it removes governance from jail anomaly and ensures executive accountability. Third, public trust. That is, strong stance against criminalization of politics enhances in institutional trust. Fourth, bridges legal gap. That is, Representation of People Act 1951 disqualifies only post conviction. This bill addresses interim pre conviction situations. Fifth, aligns with international best practices. That is, UK Ministerial Code, South African Constitution, Section 96. These says public officials facing serious charges step aside. Sixth, addresses Lily Thomas 2013 Manoj Narula 2014 Spirit. The Supreme Court has long called for stricter standards for ministers. Seventh, anti-corruption push. High, that is highlights zero tolerance against corruption in high offices. Eighth, as per Home Minister Amit Shah, it is an insult to democracy for secretaries and officials to take order from a jailed leader. Next, arguments against. First, arrest versus conviction violates the principle of innocent until proven guilty by imposing a severe penalty based on mere arrest or detention rather than a court conviction. Second, legal experts suggest the bill might be challenged for violating the rule of law and equality code, Article 14. Third, weakens Prime Minister's constitutional prerogative. That is, in Manoj Narula versus Union of India 2014, Supreme Court held selection of ministers is constitutional prerogative of CM and PM. The bill limits this discretion. Fourth, unequal standards. That is, creates asymmetry uh, between MP MLAs removed only on conviction but ministers on detention. Fifth, parliamentary confidence eroded. That is, displaces legislative majority principle under Articles 75 and 164 with police or judicial discretion. Sixth, governance destabilized. Cycles of resignation and reinstatement weakens stability and fracture coalitions. Seventh, opportunism encouraged. That is, enables ruling party to weaponize detentions to eliminate rivals. Eighth, authoritarian tilt. That it empowers law enforcement over parliament, reflecting abusive constitutionalism. Ninth, revolving door problem. The provision allowing reappointment after release from custody could lead to cycles of resignation and reinstatement. Coming to the way forward, first, address presumption of innocence. That is, consider triggering removal at charge framing stage. Law Commission 244th report said, um,